criminal defense attorney, Neil Rockheim.
Hey everyone, I'm Neil Rockheim. I'm a trial lawyer, criminal defense lawyer in suburban Detroit, Michigan. I'm called the Rockweiler because of my unique courtroom style, and I love trial lawyers. Trial lawyers are among America's last great storytellers, and we are on the front line fighting for the powers, fighting the powers that be day in and day out. And people started calling my cross-examination style killer cross-examination several years ago. And soon after I began writing about it and talking about it, we started this podcast to bring to you stories from the trenches, from the front lines, from some of America's greatest trial lawyers. We talk about tips on examination, cross-examination, trials, war stories, criminal justice, and legal issues. And I want to attempt, with the help of some of these great trial lawyers, help you see and feel what goes on in the courtroom. You don't have to turn to CSI or Law and Order or Dateline, MSNBC or NBC or whatever else it's called, because these are the lawyers that would actually appear on those shows. We want to entertain you, but we're also here to help you get more justice in the legal system and more justice in your own lives. Today on Killer Cross-Examination, I'm joined by one of America's great trial lawyers, Norm Pattis. Norm has tried hundreds of cases and has obtained not only verdicts of acquittal in some of the toughest and most notorious cases in Connecticut, he's also obtained millions of dollars in verdicts from different government agencies in discrimination and police misconduct cases. He's been referred to as the defender of the despised by Connecticut Magazine and one of Connecticut's most colorful and controversial lawyers. And I think that there's high praise when an opponent is willing to go on record and talk about your skills. And one of Norm's peers actually said, when you have tried a case against Norm Pattis, you have been put to the test. He's more at home in a trial than any lawyer I've gone up against. So Norm Pattis, welcome to Killer Cross-Examination. I'm so glad we finally had a chance to take our telephone chats and turn them into an actual podcast. Thank you for being here.
Thanks for reaching out.
So Norm, let me get a little bit of background from you about sort of how did you get to this? How did you get to your point where you became a trial lawyer? So let me begin with, like, did you know you wanted to do that when you were a kid, or did you just kind of fall into it?
No, I'm an accidental lawyer. I mean, everything about my life is contingency multiplied times urgency. I grew up in the Detroit area, not far from you. I went to Denby High School in Detroit, hated high school, graduated early, left the city in '73 and haven't returned. Nobody in my family went to college, but I had a guidance counselor pull me aside and say, you know, your grades are for feces, but you test well. What do you want to do when you grow up? And I was going to head out to Haight-Ashbury because I thought, get stoned and have a good time. She said, have you thought about college? And I thought, no, but she got me in. And so I did a year and a half at Eastern Michigan, where I learned how to study. Then I transferred to Purdue. I ended up going to Columbia for 6 years and working on a PhD in political philosophy, and didn't plan on being a lawyer. Started writing newspaper editorials because I didn't like college teaching. I taught at Columbia for a few years. And then I thought, you know, I just want to know how the world works. So I went to law school at University of Connecticut. And then my criminal procedure professor hooked me up with a guy named John Williams in New Haven, who was the dean of police misconduct litigation at that point. So I spent about 12 years with him, then went off on my own, and I've been on my own now for 15, 20 years.
When did you sort of get the idea or the feeling? Because there is a feeling, right? There's a feeling as a trial lawyer that this is where you belong. And we know that there are people that when they get into the courtroom, they aren't trial lawyers. They want to run as far away from it as possible. So when did you get when did you know that this was where you belong?
Probably the first time I stepped into a courtroom. You know, I mean, I always say I know where I'm at because when I played Little League Baseball, they'd stick me in right field for an inning or two so that my mother didn't think she got ripped off. And I'd pray that nobody hit the ball in my direction. Now, when I see a case in the newspaper, I'm insulted if I don't get the call because that's where I want to be. I want to be next to the guy everybody hates. I want to say to the government, if you want him, you got to come through me to get him. So first case I had, day after I passed the bar, my my boss, soon to be partner, handed me a file, said, go get it. I looked at it. I said, they don't have a warrant to be in this guy's apartment to get the gun. I said to the prosecutor, how'd you guys ever go in there? Case dismissed. It wasn't always that easy, but boy, I was hooked from day one.
So how long did you work for you said you worked for another firm, and
Right.
then you went off on your own. How long did you work for the other firm?
I was with John Williams for about 10, 12 years. I was going to stay for 25 trials or 2 years, whichever happened first. And so about 2 years in, I started packing up and getting ready to go. I'd tried about 20 cases, and he came in and he said, where are you going? And I said, well, you created your own golden arches. I got to create mine. He said, no, you're not going anywhere. So he made me a partner. And at one point we had as many as 8 lawyers working for us, and we had a lot of fun. So I worked with him and was his partner till I was about 49. And then I thought, I'm turning 50 next year, and if I don't work on my own, I'll never do it. So I did that and haven't looked back since.
So let me ask you, so some of the things that I like to try to learn about people is about trial lawyers. When you started off as a trial lawyer, did you have any training in the courtroom? Did you sort of kind of pick it up as you went along? Did it just come naturally to you? And kind of take me through that so that young lawyers can see how you can get from point A to being somewhere like you or someone like you in your career.
Yeah. No, well, I studied political and moral philosophy, and I was very interested in what we can know. And I was preoccupied with the authority of the state. Like, how do you account for it? Immanuel Kant, the 18th century philosopher, once said that 2 things filled him with wonder: the starry heavens above and the moral law within. Me, I'm mystified by how people I never met get to tell me what to do, maybe lock me up and kill me, depending on what prove. And so I have issues with authority, and I come by them honestly. My father deserted our family when I was young, and I've always been kind of mean and kind of ornery and had to fight for everything I got. And so I think if you're a scrapper, you're a born trial lawyer. I think if you've had adversity in your life as a child and you walk into a room, my mother once married a man, lived with him for many years before she married him, didn't care for me. I was unwelcome in my own home. And when you get used to fighting for your table scraps, when you get used to fighting to be present where you're at, I think that's what a trial lawyer needs to do. You walk into a courtroom in a criminal defense case, people want to know, what did your guy do? And your immediate mission is to flip the narrative. We're not here to sit in judgment of my client. We're here to sit in judgment of the state's case and whether they can prove it beyond a reasonable doubt. And so I think if you got a chip on your shoulder, you're halfway there. And then it's a question of implied intelligence and not taking anything for granted. The evidence code is your best friend.
So what do you mean? So first of all, you said a lot there. So I too have that feeling, like, in a way, the more reviled, the more the courtroom is sort of the gallery is stacked against me, where they've all got the pins and the t-shirts, and the angrier I get, the more I want to win. It's sort of a underdog mentality, right? Like, I want to fight for the underdog. And then you said you want to flip the narrative. So that's a really important concept. So people always want to know, I'm sure, they're like, Norm, how can you defend this guy, or how can you defend that guy? And then you just said you don't want to sit in judgment of our client, of your client. Could you expand on that? Because that's a really important thing that I think people lose they don't understand about how we're wired as criminal defense lawyers.
Yeah. Well, no one is the sum of their worst moments. I'm persuaded of that. I mean, there were any number of times as a young man that I could have taken a turn and then ended up behind bars rather than trying to keep people out. I recall as a young man, my mother's lover once beat a fellow up with a baseball bat, a neighborhood drug dealer, and the drug dealer called to say he was coming to get him. So I was handed a gun and told to sit out back. I was 13. He went out front with a handgun, and my mother wanted to call the police, but we didn't do that in Detroit, not in those days, maybe not now either. And I sat out back knowing to a moral certainty I'd shoot to kill if anybody came in, but I was praying that they'd come out front and kill the son of a bitch out there because he brought so much turmoil into my home. Does that would I have been a criminal if I shot someone? Well, I would have broken the settled expectations of the law, and I would have been held to account, but I wasn't a bad guy. I was a scared kid. Now, very few of the people I've represented are evil, and I'm not even sure I know what evil means. I think people make horrible mistakes. People are driven in directions that twist them into caricatures of a robust human life. And I like to think that we're shepherds. I often read Psalm 23 with clients before verdicts or before a very difficult court day. The Lord is my shepherd. That's very powerful stuff. So for me, I want, my father, as I mentioned before, my father left when I was a kid. I was involved in the Big Brothers program. My big brother was from Grosse Pointe. So I get to talk about that with your audience. I assume you're nationwide, but you're close to home.
We are, but any story in which you talk about Detroit or suburban Detroit is near and dear to me. So I appreciate that. So
I'd get to go every couple of weeks out to his house and spend the weekend with his son and eat a normal meal. And, as chaotic as my childhood was, when he was in my life, his name was Herbert Steiger. He died a couple of years ago. I always knew that 5 o'clock at Friday, if I waited at a certain corner, he'd pick me up. And I want to, and somehow I'm repeating that drama over and over again, because when the gavel falls, no matter what you did, I'll be waiting for you with my hand out in the courtroom when you come out of the lockup or enter the courtroom. I will shake your hand in the presence of everyone to humanize you, and I'll dare somebody to say something about it. And because I guess I'm that kid still.
I get that. I think that's, it's funny that so we all have our own stories about how we ended up getting to this point, but you do have to have a bit of a chip on your shoulder.
Yeah, you do. Nobody in their right mind would do this.
and you have to, I've often said, I want to win. I definitely want to win these cases for my clients. There's no question about it. But I want to win for me too.
Yeah.
This is important to me. I want to win. I view this as a battle in a way. And I have often said, I'm so glad to hear someone of your stature saying, if you want to get to him, you got to go through me.
Yeah, I always joke with prosecutors, there are 2 ways we can work this case out. There's my way and the hard way. And I'll let you pick. But if you pick the hard way, you're going to regret it. Win or lose, you're going to regret it.
So we're getting a sense of your style, I guess, in the courtroom. I mean, how would you describe it? How would you describe your style?
I have no idea. It depends on the case. It depends on the jury. It depends on the judge. I did my first stand-up comedy routine the other night in front of a live audience, and I was stunned at how similar stand-up comedy was to a courtroom. Because when you're in a courtroom, you're filled with your own anxieties and the anxieties and expectations of everyone there. And your goal is to bring them to a place. Hopefully a place where they'll repeat the only 2 words you want to hear, not guilty at the end of the case. And you'll do anything necessary to bring them along. And so strategy and tactics depend a lot on the jury. I hear a lot of people talk about jury consultants. For me, it all comes down to bounce. When I'm picking a jury, I'm looking for bounce. And what is that? You walk into a bar in a strange town, you got an evening to kill and you don't know anybody. Who do you end up talking to in the whole crowded room? You talk to the person who gives you a little something back, who gives you a little bounce. I'm looking for bounce in the room. And sometimes that takes humor. Sometimes it takes anger. You need the jury's permission to show too much anger. So there's no typical trial. There are just some cases that are tougher than others. And sometimes you got to take the judge on. There are judges.
So what do you mean? To expand on that. So there are a lot of trial lawyer schools and books and lectures and guides, and a lot of people are told, a lot of young lawyers are told, be yourself, but not the self that's funny, or not the self that's angry, or not the self that raises his voice, and not the self that gets mad, and not the self that is sarcastic. And so do you find room for all of those different parts of because you're obviously have the capability of telling great stories and of being humorous and self-deprecating and being obviously, passionate. I'll even say angry at times. Do you find room in your trials for all of those parts of your personality?
Yeah, but not always all at once. The concept of permission matters. Early on, you walk in, the first time the jury is seated, the judge is there. The judge knows more or less what the case is about. The prosecutor, know what the case is about. The jurors know nothing. So they're afraid, and they're looking for someone to trust. And so I think what you're trying to do is connect with them and be a trustworthy guide. And sometimes outrage is called for. Sometimes you need humor. The most humorous event that ever occurred to me in a courtroom was also one of the most embarrassing events in my life. It was one of the first cases after 9/11. And my client had issues. He wanted to be a drug dealer. He stole guns from his girlfriend's father's prominent state police officer. Police had him as a suspect, he and another guy. The other guy was found dead in the woods. Our client went missing for a year or so. When he turned up, they were looking for him, and they set up a sting. They thought he'd go to the girlfriend's house one night and she was to lure him. And to get to her house, he had to pass through a narrow passage in the woods. They jumped out in raid jackets and all hell broke loose. He started shooting. So our defense was self-defense. Yeah, he's a bad guy, kidnapping, murder, everything else, but he wasn't a cop killer. And so I was trying to demonstrate to the jury just how dark and confusing it was out there. And in the jury room there, I've got the raid jacket on the floor and the pants, and it's all black, and I bend over to move something, and all of a sudden you hear this, and I cut one of the loudest farts that you could cut in a courtroom without being held in contempt. So I went from 6'1" to about half an inch, and I turned around and everybody was mortified. And I said, ladies and gentlemen, you can laugh. And they brought the house down, and we got the acquittal. Now, I don't think it was because of that, but you've got to reach out to the jury. You've got to show them that you're one of them.
So that's a great story, and that's a very humanizing story, because I don't want to say you cut the tension with a knife, because you cut it with something else, but how do you get permission? I know that, and I asked some other of our peers, because you can't just say, can I, unless that's how you propose to do it. How do you get that permission?
Well, so, in a jury, whether it's 6 or 12, you need to work each juror. I was involved in a NITA class years ago, and I'll never forget it. We were taught to make eye contact with each juror, and the exercise was to walk in a mock argument, to shake hands with each person as you gave your argument. And in the course of the exercise, I was a mock juror, and the lawyer never made eye contact with me. And 25 years later, my feelings, both of them, are still hurt. And so I make a point of talking to each juror. And then there's the concept of mirroring. Let's say you've got a juror who's sitting there like this the whole time, and they're just not giving you anything. You're not getting any bounce. So then you start asking questions of a witness, mirroring their body language. And if you look at them, they'll look back. And when they release their hands, you release your hands. And suddenly you've brought them back into your orbit. They may not like everything that you've done, but they want to be courted, I think. And so you're pleading your case to the jury as a group, but you're also pleading it more particularly to individuals. And you don't want to be a robot. Every fifth word change who you look at. But you need to court each juror. And you know it when you got it. And sometimes
do you use jurors' names when you're talking to them during jury selection? Are you allowed to do that in Connecticut? Do you do that?
If you are, I'm so spaced out, I can't remember my own name half the time. So I keep it a little formal, and I'm pretty quick at jury selection. We have individuals sequestered voir dire as a matter of right in each case. So there's not a murder case that I've ever had where I've taken less than 2 weeks to pick the jury. I watched the George Floyd thing, and everybody was marveling at the length of the proceedings. I was stunned at how quickly it took place. So I will question each juror for 15 minutes, maybe a half an hour, but I usually know within a minute or two whether there's bounce there.
That's an interesting concept. I appreciate you sharing that. The idea of who can you talk to and who gives you kind of that feedback. Who would you have a beer with or a drink with if you're in a bar?
Well, I once had group voir dire in a federal case. It was a very, very difficult case, and I did something a little different. I only did it once because the judge was friendly and he let me get away with it. But my client had faced a death penalty in Connecticut for the rape and murder of his 16-year-old girlfriend. And he'd beaten her so badly, her face was unrecognizable at the emergency room. And what's worse, he did it during the Christmas season while she babysat her 3-year-old sister. So obviously the state was motivated to kill. It didn't get the death penalty, but it got life without possibility of parole. And he was at a community correctional center. As he was waiting for sentencing, he realized he had one last chance to escape. And so he looked around and he saw a guard about his side. He listened carefully. He knew what kind of car the guard drove. So one night he made his move. He lured the guard into his cell, held the guard with a shank, a homemade prison knife, said, "Give me your uniform." When she said no, he stabbed her in the chest, gagged her, and put her uniform on. He almost made it out. He got past 2 checkpoints. When he got to the 3rd, they found out who he was, chased him down the hall. He ran. They pushed him down. The shank went into his chest. He thought it was his heart. He didn't resist, and they smacked him around. So the public defender's office called and said, would I sue the guards? And I said, yeah, sure. And so here was the voir dire, group voir dire in federal court. I had him in his prison orange I left the chains on. And I said, ladies and gentlemen, you're wondering why he's sitting there with chains like an animal. This is what he did. And we're not here because of that. We're here because when he tried to escape and he stabbed a guard, and I told the story the way I did to you, the guards beat him up. How many of you think I got a lot of nerve coming in here asking you for money damages? Half of them raised their hand. So I said, the biggest guy in the group, why'd you raise your hand? And he said, whatever. Judge calls us up to sidebar. Norm, you got to get rid of these people. They're killing you. I said, let me pick the jury. You call the balls and strikes. I'm not batting right now. All right. So I let him talk for a little more. And then when they were done, I said, look, anybody else want to join this group and think they couldn't give my guy a fair trial? So maybe 8 people raised their hand. I said, those of you who didn't raise your hand, can you see why those guards figured they'd get those folks for jurors when we came in here? And as luck would have it, we got a $2.1 million verdict for that guy. He got $150,000.
This is the Kevin King case.
Yeah. And I think it was because we were real with the jurors. And we didn't hide anything.
Did you leave any of the group? So you're talking about group formation, obviously.
Yeah,
that was trying to get the jurors to begin forming groups before you even start the trial, so that there's, so you kind of are pitching to the group and not to individuals. Did you leave any of those 8 people on the jury, or did they all end up getting tossed?
No, they were eating lunch talking about that asshole lawyer while we picked. They were out of there. They were out of there when I wanted them out, not when the judge wanted them out. I used them, frankly. That's
such a great question. I represented somebody in a murder trial who was accused of killing a police officer. This is years ago. And it was a very difficult case. I mean, as you can imagine.
Yeah.
And I kept on trying to think of how could I develop some of I had a similar idea. And my idea was that I just said, you've heard about the case. These are the basic facts. I was trying to get it out before I got one of those, judge, just ask your question, Mr. Rockine, trying to get it out. And I said, okay, so here's who thinks he's guilty?
Yeah.
Like, who's sitting there thinking, like, why are we going through this? And, hands start raising, and we start asking questions of those prospective jurors. And then there's a couple of, souls left that didn't raise their hand, probably because they didn't hear the question, but I said, how about you, Mr. Pattis? You didn't raise your hand. You go, I think you should get a trial. Okay. Anybody else? And then I came back to you and I said, so you said a trial, like a real trial, like a trial. Yeah. A trial, like a real trial where they got to prove the case and you're going to listen. And what would that trial, what are some of the things that you can, conceive as you're thinking that we would be talking about during the trial? Like, did he do it? Was it accidental? I'm like, was it accidental? Was it provoked? I mean, and as we went around, we get the same thing, got rid of all the jurors that, had their arms crossed and were like, but it was such a great way because I told them the truth. I could totally imagine that many of you are sitting here thinking like this is a total waste of time. Some of you are probably thinking like, I want to sit on this jury to do justice to him, and I know that there are people thinking that because I have people that are close to me that are thinking that, which is a way to be honest with that. That is an honest feeling. Yeah. And so do you have you I know that at one point in your career you worked with Jerry Spence in the Trial Lawyers College. Mm-hmm. Was that a help? Did you learn some of these tactics or techniques or approaches to trying cases there, or were these things that you kind of learned on your own?
A little bit of both. I think it's funny you should mention Jerry. I saw him today. He's 92, and he's not trying cases anymore, but he's still one of the best storytellers I've ever met. I'm not sure the Trial Lawyers College helped me per se. I think it made me more self-conscious and as opposed to more spontaneous. I think I was always out. I think I was born outside the box. I mean, I'm 65 years old with a ponytail. So I think for a couple of years I was trying to be like the big boys at the ranch, and I struggled some. But I can tell you in the Kevin King case, the prisoner case, What made that case is we were all out there in Wyoming one night, and there was a mock jury. Jerry Spence was in the jury. Racehorse Haynes was in the jury. Milton Grimes was in the jury. 4 or 5 other lawyers who, I clearly admired. And I gave the closing argument in King. And Spence came out, put his arm around me, said, "You cannot lose that case." And I'm thinking, he's out of his frickin' mind. But he was right. And so I think the Trial Lawyers College and Spence's pedagogy focuses around psychodrama. That is, getting in touch with your own feelings, being vulnerable to a jury, being open to inconvenient truths and putting them out there. People run from the bad news in their case. I think you need to embrace them, embrace the bad news.
Tell me about that. So inconvenient truths, bad facts, how do you deal with those things? First of all, I just want to ask you a question about the Kevin King case. So that voir dire, did it come to you that way to approach the jury in that group question? Was that something that you just did on the fly, or did it take you hours upon hours to sort of think of that approach?
That's a tough question because everything always seems like it's on the fly to me, but I'm aware of the fact that, I ruminate all the time. And so I think the best thinking you do about a case is when you're half asleep in the middle of the night and things come to you. So I sleep with a notepad next to me and try to write things down. And some days it all just comes. Yeah. And sometimes, I don't know, I'm sure you've had the experience where you're in court and it's just going and you're like, damn, that's pretty cool. Where'd that come from? And it came out of your mouth. And I think, even that business about the 10,000 hours, once you've done this long enough, you've kind of acquired enough. Here's what I say to young lawyers in my firm: you got to do 3 things at trial. Try to win, and if and you don't know that till the end. Preserve issues for appeal, so your client's got something to fight about another day if you lose, and then force error. Find areas where the law is in tension, the judge is unsure, you can get the prosecution unnerved, and then put the pressure on. Try to make something happen. Maybe get a mistrial, maybe get a bad ruling, but forcing error is where the rubber meets the road. And that's the true joy of trial work. So I think, and how does that happen? You don't really know often. Sometimes you'll have a novel issue that you can see coming a block away, but you've got to master the law. And so I tell people, go into trial, learn how to lay trial number 1. Learn how to lay a foundation for past recollection recorded. Everybody forgets something. Trial number 2, learn how to impeach somebody with a prior inconsistent statement. Trial number 3, refresh a person's recollection without using the past recollection recorded doctrine. Don't try to do it all at once. And when you've mastered one skill, put it in your quiver. And 15, 20 trials down the line, you've got 15, 20 arrows in your quiver, and you can draw them really quickly. And so, your prosecution asks the question, maybe you didn't half hear it right, or you don't like the way the sound of it is. So you stand up, and by the time you've gotten up, you've laid down 4 bases for objection, and the prosecutor's still trying to remember what the first one is. That's when you're in hog heaven,
So tell me, I love hearing, I like knowing whether you're the sort of lawyer that has to, do you sit there and prepare and do an outline for your trials, or do you just have some kind of, vague notes and just kind of wing it?
Both. I think trial is almost all tactics. The strategy, somebody says, what's our strategy at trial? Our strategy is to create doubt by any means possible. And so you master the discovery that you've got. When I was a young lawyer, I obsessively outlined police reports by what I called the zipper method. So I would take a police report and I would outline every material noun. And then I would list the noun in one column on a piece of paper. And then as the person testified, I'd keep a list of the nouns to see if they matched. And every time they mismatched, I'd have the first thingamabob in the zipper on the cross-examination. Sir, do you remember testifying 6 minutes ago that the car was red yet? Well, you wrote a report 4 years ago, yeah, and then you said it was burgundy in there. Now, do you see a difference between red and burgundy, or is it all the same? Sir, you testified it was 8:10 today. Do you remember 4 years ago saying it was 7:30? Now, I realize it's evening, but there's a difference. The small details matter. And so I spent years doing that zipper method. Now I don't, maybe I'm getting lazy. Or maybe I've got a better memory, but after doing so many reports, they kind of come to you, and then there are those moments you can't plan for. I remember a case once. It was a doctor who was accused of having sex with one of his patients. And so she comes into court one day And, she didn't come into court having recently attended a Mensa conference. She was cognitively impaired, and she's kind of plump, and she's talking about how he put his man thing in her. And I'm like, well, that's not good. And she had her skinny jeans on, and they show a set of skinny jeans to the jury. So, and I'm thinking, and she had her jeans on while he did that. And I'm thinking, so I say that, so I'm thinking to myself, how did he get it in there? I mean, he must have gone from behind, because you can't get in on top that way. But how do you say that to a jury? So I got her up there, ma'am. When Dr. Njoko put his man thing in you, was he on top of you or behind you? Well, she didn't understand the question. Ma'am, did he come in from the front way or the back way? She didn't understand the question. So I made a couple passes at it. I looked at the jury. They were getting frustrated. I looked at the prosecutor. They were getting pissed at me. And then, without asking anybody's permission, I lay back on the prosecutor's table, spread my legs in front of the jury. I said, did he come in this way or the other way? And she had him coming in on top. And, everybody was like in shock. So in closing argument, I said to the juries, I said, I'm an old man now. But it's been a long time since I had those hand-to-hand combat sessions in the backseat of my dad's car, or somebody's car. But when I did, I didn't get in on top the way she said he did, because it's physically impossible. And we got the acquittal there. Now, that was a huge risk. And I don't know that I'd recommend it to anybody. I don't know that I'd do it again, but it felt right then. And you don't plan stuff like that,
So when you got done doing that, did you have any feeling like, I went too far, or did you think that it was?
Because, no, I'd given her 4 or 5 chances, and it was pertinent testimony. And, the judge was, kind of a tight sphincter, to put it politely. And the prosecution was shocked and just didn't know what to do. But I just there was blood on the water, and I wanted it. So I went after it.
So I've heard you use that phrase before.
It could have been.
You came to Detroit.
Backfired on me. It didn't, but
No, it didn't. And listen, it obviously didn't. But I was just curious, because I know that there are people that were wondering what you were thinking as it ended. Were you nervous? Were you, were you? But
I was. Well, to me, I use the courtroom as a theater and as a prop. I've argued cases lying on the floor. If my client was being beaten by a cop on the floor, in the King case, I argued part of the closing argument on the floor, on my side, wincing. Some judges don't permit it. I've gotten in the witness box and pretended to be a witness in closing argument. I've cross-examined empty chairs. I had a case at larceny once. The state blew the statute of limitations. The woman clearly took the money. It was a bondswoman. It's a long story. But they brought the wrong charges. So I said, ladies and gentlemen, I can't cross-examine my adversary here, because the state's a legal fiction. It's unfortunate, but true. I'll never meet it. But boy, if I could call the state of Connecticut as a witness, the questions I would ask. So can I do that, ladies and gentlemen? They nodded. I call the state. The state sits in the chair. I said, state of Connecticut, welcome to my courtroom. I've got one question for you. What in the hell were you thinking when you brought this crazy case? And the jury laughed. And the client was acquitted. And
great story.
That's sort of like the stand-up the stand-up comedy lawyering thing becomes the same, and somehow it felt right at that time. I'm sure I've blown many of those opportunities.
Well,
I remember.
Listen, I think those are wonderful anecdotes, because I think that if there are moments where you believe that it's possible to help your client, to help your case by being self-deprecating, or telling a joke in that way, I think that you should. Obviously, you don't do it if you do it at the wrong time, or you force it. That could be really, that could be bad. But if there's an opportunity, and you have to know, don't you agree, when that you have to be able to feel that opportunity, and you have to be able to squeeze yourself in it before the window closes,
before the other side has the sense to gather their wits and object. Absolutely. We talk about cross-examination as the great engine for truth. Well, it's that. But really what trial is, it's a search for the truth, but we don't ever really know the truth. We just know which narrative best captures the facts. And I think you want to bring your narrative to life, and you want to bring the jury around to seeing things from your point of view. And action sometimes speaks louder than words. So I'm a very peripatetic trier. I'm all over the courtroom. I don't know that I'd do this again. I got away with it. I argued part of a case from behind the jury box. There was a particular witness behind the jurors. I was looking at the jury box, and a witness had gotten up, and his lawyer led him. It was a police officer, and he said that the officer said, "Now, were you concerned about nefarious activities?" And the cop said, "Yes." And I'm looking at the cop, and I'm thinking, he doesn't know what nefarious is. So I'm behind the jury with him, and I said, "Ladies and gentlemen." I said to him, "Now you talked about nefarious activities." "Yes." "What were those activities?" "I don't understand the question." I said, "Is it the question you don't understand, or the word nefarious?" "Nefarious." I said, "Well, then why, when your lawyer," and I'm behind him, "why, when your lawyer asks you about a nefarious activity, you agreed? Are you going to agree with anything he says and just argue with me because I'm here?" And we lost that case, and maybe the jurors just didn't like me getting too close to them. So I can't say I get it right all the time. It's a work in progress.
No, none of us get it right all the time. That's why one of the reasons why I think this is first of all, I do think that trial lawyers are among the last great storytellers, and people love reading books about, fiction about trials and trial lawyers and fictional characters, but we exist in real life.
Yeah.
So this is an opportunity for people to hear more about, like, these are incredible anecdotes, that any one of which could be, a series episode right on Netflix. I mean, you could do a whole series about the case in which you called the witness, like the Encyclopedia Brown, the day that Norm called the state of Connecticut as a witness. You know what I mean? And it would be. So let me ask you a little bit about some of your cross-examination, like your styles. Are you an aggressive cross-examiner? Are you a sarcastic cross-examiner? How would you characterize yourself? And I know you're going to say it goes from case to case, but
no,
generally speaking, how would you characterize yourself?
I have to fight against being a bully and a mean streak. I love words. I love verbal play, and I have a tendency to be too aggressive. And so I have to work very hard not to come out too strong. And I'm working at being very brief. I was back in court this week for the first time in a while in a tax fraud hearing in federal court. And my client was accused of jimmying up tax returns. And so in some cases, by giving bogus Schedule C income so that people could get tax credit, at the low end of the tax code. And so one witness walks in, and she's got $2,600 of reported income on her return, and a tax return of $6,000. And so the government, you didn't have this Schedule C income. No. And the woman's, very composed. So I figured, this is just not possible. And so I was a little aggressive with her, but in a playful way. There was no jury. I said, "Ma'am, how did you first hear about my client?" "She was referred by so-and-so." I said, "They must have told you she was an absolute Jesus, right up there. Genius, right up there with Jesus, water to wine and all that stuff, huh?" "Huh? What do you mean?" I said, "Well, you walk in there with $2,600 of reported income. She does your taxes, and the government's giving you twice as much money back. That's pretty amazing. Wouldn't you agree?" "I just trusted her." "You just trusted her? What about your own eyes?" "I just trusted her." "Well, your own eyes read the business at the bottom there about perjury on the return." And, it didn't really matter what she said after that. That was the whole cross. Now, what's the judge going to do with that? I don't know. So that was brief. There are times when patience is required. I had a kid once, the so-called tennis shoe murder case. He confessed to firing in the direction of a guy who stole some tennis shoes one night. And the cops came to his house the next morning. He didn't realize he hit the kid, but he dropped him a shot through the back of the head. So he lied about who fired. His uncle was with him, but he didn't want to say his uncle fired the shot because his uncle was a felon in possession. He's going back to the big house. So after the kid signs a statement, they say, oh, by the way, he died. So he's confessed to murder. And now I've got a problem on my hands because that's pretty good evidence, right? So we get and so we get into court and the cop is loaded for bear. And so I patiently and tried to keep my temper and did, and walked him through the whole interview for several hours and just kept saying, and you lied to him here, and you lied to him here, and you lied to him here, and you lied to him here. And that was a different kind of cross. No Perry Mason moment, but that was sort of an acid rain cross. And in the end, we put the client on the stand.
What do you mean by acid rain cross?
So in the Perry Mason moment, you weren't even there. Correct. Oh, I'm sorry. I lied.
Right. That guy did it.
Yeah.
Right.
Acid rain crosses, you just wear the witness out, reminding the jury about what your theme is, one question at a time, and just let each drop sink in. So in the tennis shoe case, the client got on the stand later, explained his lie. We put on reputation for character for truthfulness, and he was acquitted. And I think, I know you had Bailey on about 4 weeks ago. Bailey saw that cross and was included it in the appendix of one of his books. So he must have thought it worked. And if it works for F. Lee Bailey, it works for me.
That's a very high honor indeed.
Yeah.
Tremendous. Yeah. So you've had, so I want to ask just a couple of questions if I could. Tell me a little bit about your, do you come out of the box with for example, I talked to Jeff Lichtman, and Jeff says that he describes his style of lawyering as suffocating. So it's his goal right off the bat to be in the witness's face. And, F. Lee was a little more like, he wants to kind of feel the witness out and then to see where there's vulnerability and then to strike.
Yeah. Where
would you put yourself in that spectrum?
It depends on how the witness makes me feel. I'm largely intuitive. Some witnesses scare the hell out of me. And if I'm afraid of them, I'm not going to attack them because I'll get desperate and the jury will see my fear. And so those I try to win over. Experts can be difficult. So one way to neutralize an expert is I call it the rope-a-dope strategy. You challenge their qualifications to get the jury thrown out of the room, and then you just beat the shit out of them as rude as you can be. Like, PhD psychologists love to be called doctor. So you keep calling them Miss or Mr. and they get all pissed. And the judge is screaming at you, the prosecutor's objecting, and you're behaving like a total ass. And then they're qualified to testify. And then you stand up and the jury's thinking, this motherfucker, I'm going to get him. And the jury comes in and you say, hi, doctor, how are you? My name's Norm Pattis. We've met. Yeah. And they're looking at her, you're looking at the jury like, what's the matter with this woman? And so that's one way to neutralize things a little bit going in. I had a guy.
Do you try to learn the science, Norm, when you're examining an expert?
Oh, absolutely.
Because I know that there are lawyers who try to stay away from the science. That's not that has not been my experience. My experience has been to go and learn the science as much as I can so that I can go toe for toe with them on the scientific evidence. Well,
you told me we were going to do cross, so I had to think about cases. So it's not like I've had all that many, but this is another one that with the knowing the science and a technique in cross saved a client's life. A woman was accused of manslaughter, 4th of July, driving home from a family picnic. She had on somebody else. 2 of her children in her own car are dead, and she and the surviving child are seriously injured. The other folks are fine. The state wants to put her away. So they take her to the hospital. She's banged up. She's got a lacerated liver. And so her blood alcohol comes out at some prohibited amount. Well, it turns out that the alcohol dehydrogenase from a lacerated liver will produce a false positive on blood chemistry, the gas chromatograph. And a gas chromatograph is done in a hospital overstates by some amount the blood alcohol on a breathalyzer. So they brought in the state's chief toxicologist. We did the work. And the Terrence McCarthy look good cross technique, right? So you give yourself points for every yes, 1 for a no, and 0. So I figured I got to bat 100 for a while. I got to train him to give me yes. So I just went through the basic science, Boyle's law, this, that. And for about 15, 20 minutes, I was just getting yeses, yeses, yeses. And then, then it got time to do some work, and I wasn't afraid of him anymore. And he was showing me a little bit of respect because I knew more than he thought I would, which was nothing, I presume. And then I started in, and I got him to concede that the two methodologies, the hospital test versus the breathalyzer, overstated it. I got him to give me, by using learned treatises, the alcohol dehydrogenase from the lacerated liver. And I had almost everything I needed. And he'd been up there for a couple hours at that point and hadn't had much of a chance to disagree with me. And then I thought, well, let's see how far I can push him. So I made a few things up, and I got him to agree with me on those too. And I didn't tell the jury about that. I just needed a few little things to feel comfortable. And he called me up afterwards and said that was quite a beating he took. But in that case, it was from knowing the science and then knowing Terence McCarthy's method and just being patient. Couldn't show any anger there. Everybody felt bad for the mom. But, dead babies, I mean, it's a bad case. But she ended up walking away from that case.
So speaking of difficult witnesses, like, for example, I know you obtained, now in the news, it seemed like it was a miraculous acquittal. I think your client's name was Saifullah Khan. Was that?
Yeah.
But that case, you obtained an acquittal. Give us the background, the backstory of that case.
So Saifullah Khan is an Afghan refugee who was found at a refugee camp in Pakistan. His family had been murdered by the Taliban, some members of them. And brilliant kid. So Yale talent scouts found him, sent him to a boarding school in northern Connecticut, and then brought him into Yale on a full scholarship. Very charismatic, brilliant. On Halloween, I think his junior year, he took to a concert, a young woman, and they ended up in her dorm room that night, heating the sheets. And the next morning, she cried rape, and so she needed cross-examining, and it was difficult because there was lots of difficult facts in that case. And so our defense was consent. And she came into the court to testify, and the jury came in, and I knew we were in for trouble because one of the female jurors had a box of tissues. And I'm like, okay, it's going to be one of those. And so the prosecutor went into his client or his victim, and he took far too long with her. And and I noticed that people weren't touching the tissues. Nobody was crying. She was diffident. She couldn't give straightforward answers. And so I started in on her. And I don't think the prosecution had really prepared. She had sent my client days before the Halloween event a text message, and in it was a Shakespearean sonnet. And so we had that from Discovery, and I started to read from the sonnet to her. And I said, are those the words you send to somebody on a casual date, or do you normally send love sonnets to people you're going to spend an evening with? I didn't read it. You didn't read the sonnet you sent him? No. And I just stayed on her. I mean, I took a beating in Time Magazine, of all places, for asking her about the outfit she wore that night, a cat suit, or her costume. And I said, you didn't go with Cinderella, you went in a cat suit. Why is that? What message were you trying to send? But it was the state who had introduced the cat suit. And then there was unusual testimony.
But you can't be worried about that. You can't be worried about.
I didn't even think about it.
The news is gonna characterize, you know what I mean? Like, your number one job, the only person that you are focused on is your client, whether what you're doing works for the client or not.
And the jury. And I had that. I knew where that jury was. There were a number of rape, sexual assault in the first degree in Connecticut. There are lesser included offenses that entail lesser assaultive conduct. And all 4 forms of sexual assault were put before the jury. The jury acquitted in less than an hour. And so this young woman just was not compelling to the jury. And I don't know that I don't know whether she was just not compelling or whether it was a combination of that and the cross-examination, but he was very fortunate to be acquitted.
What's your favorite cross-examination war story?
Probably, I already told it, probably the gas thing with the, when I farted. I mean, that was just so outrageous, or probably that. I mean, and then there are cases that are just shocking. I mean, I've never had anybody die on the stand, but I had a guy soil himself and walk off the stand with the soil coming out of his pants across the courtroom.
Did you know that he had soiled himself on the stand?
I knew he was not feeling well that day, and I could see what I thought was feces coming out of his pant leg as he walked across the courtroom, and I about died. I mean,
nowadays we would say, "Man, Norm, you made that guy shit himself." Like, that's what we would.
I think he was just sick. This was a guy. This was actually the civil side of the tennis shoe murder case. My client was acquitted of murder. The estate of the decedent brought an action against him for wrongful death. He tried to discharge in bankruptcy. We ended up trying the case civilly in front of the jury, and this was the decedent's father, and we won it there too. So,
What's amazing is that I never envisioned, when I started this discussion with you, that two of the highlights of your cross-examinations over the hundreds of trials that you've tried would revolve around flatulence and defecation.
Well, I probably should have thought more carefully about that.
No, those are great.
Feces lawyer.
These are great. Not shitty lawyer, but
yeah.
No, those are great stories. So these are awesome stories. And this is why I think that, I keep telling people, you tune into all these shows on Netflix and Paramount and Peacock, whatever, about fictional lawyers that are with Law and Order has like a 35-second cross-examination of a police officer who, in a case, and we all know, you and I both know, that nothing has been done. You can't even make an egg in 35 seconds, let alone cross-examine a witness. So, Norm, who would you say is the best cross-examiner, the best trial lawyer you've ever seen? Even Bailey paused when I asked him that question, because he wanted to say himself, but even he paused.
Yeah. Well, Bailey is by far the best fact trier I've ever met. To this day, when I have difficult clients, I will take them to him. And we had a case involving a missing mother in Connecticut that made a lot of news, the Dulos case, and we took Bailey. We worked with Bailey in that case for a while, and he always spots something in the facts that I didn't see. But I've never tried anything with him. Spence, for his ability to mesmerize a jury and his ability to become his case, remains extremely impressive. There was a very understated prosecutor named, oh, doggone it, I'm drawing his name. He was up in Middletown, Connecticut. I'm so upset that I can't remember his name, but he had this sardonic way of reducing you to looking foolish. So, after I'd done a voir dire of a witness at one point, he stood up, he said to the jury, he says, "Now, you don't really think I get out of bed in the morning and pick a name out of a hat, decide that'll be a defendant, and then spin a wheel and pick the charges based on that spinning wheel, do you?" No. And, and he's looking right at me, and I'm like, okay, you did, So I don't know that I want to name a big name. And I'll be honest, this is going to sound really narcissistic. I'm not going to say me, but I'm just going to say I don't watch other lawyers try cases that often, because it's like watching ice melt. I can't watch it on TV. When you're in the moment, there's nothing more interesting than trying a case. But probably if you're not trying it and you're a trial lawyer, there's nothing more painful than watching somebody else try a case, because it's like chess, or it's like Go. There's an infinite number of moves, and each question is a branch that goes in many different directions.
I know you've done some television commentary. I've done it too. It's one of the more difficult things to sort of, when you watch the daily commentators in the high profile cases kind of talk about who won the day, which is of course just nonsense, because there's no winning the day and losing the day. I mean,
Yeah, as I've gotten older, I just can't even do press. I used to look at press coverage in my cases thinking that's like 13th juror, but I don't even recognize the case half the time. I've been reading a little bit on the Derek Chauvin case. I'm not even sure what to believe there. The media have a tendency to report the highlights of direct examination and nothing about cross. And then, it's just the state of court reporting in this country is abysmal. It really is.
I agree with that. In fact, there's a case that I handled where I'm so glad to hear you say that, where I actually I knew that there was a reporter who was going to do a story about it. And I was like, God, here's the transcript. Here's the court order. And then like, these are the quotes from the transcript that you should be, like paying attention to. And sure enough, when the article came out, none of those were quoted.
Yeah, Norm, I've got 2 cases in mind that are going to be on Lifetime movies in June. And so people are calling, oh, you're going to watch them. No, I'm not going to watch them. I'm just going to get pissed off when I watch, because that's not what happened. Or
which ones of yours are going to be on Lifetime, a Lifetime movie?
The Fotis Dulos case, that was the missing mom. He killed himself before trial.
Yeah.
And then
what's the other one?
Manhattan Madam, Anna Christina. So that was.
You've had besides the couple of cases that you've talked about, a lot of your cases, some of your high profile cases, but I would be remiss if I didn't ask you about Alex Jones. So you represent Alex Jones. He's a client of yours.
Yes.
Okay. So to the extent you can say it, first of all, what is he like? Is he like the guy on television, or is that just a character? Or is he a totally different guy?
He is the guy. No, there is no guile in Alex Jones. People say, does he believe it? He does. Alex is a force of nature. When I need a couple hours of his time, I'll go down to Austin to spend a week, and they'll make an office available for me, and I'll catch him 5-10 minutes between the 1,001 things he does in an hour. And in the course of a week, I'll get the time I need. He is an intuitive genius. He gets a bad rap as a quote unquote conspiracy theorist, this, that, and everything else. But the bottom line is he's got millions of viewers, and he's got millions of viewers, not because of what he's selling, but because of what he's saying. And he's meeting a need in this country. We have a crisis of legitimacy in our institutions. He offers an alternative narrative that people find persuasive and compelling. He's a generous guy. He's got a temper. And boy, I'll tell you, he's a handful. I thought I was wound up until I met him. He makes me feel calm,
Now, do you anticipate that case? You represented him in the case involving Sandy Hook, is that right?
Yes.
And do you anticipate that case going to trial? Is it on a trial track, or is it still in the appellate courts?
No, we're out of the appellate courts now. It's on a trial track, and I expect it will go to trial.
And are you just any idea when that case will be up for trial? I'm sure it'll be noteworthy at the time.
Yeah, probably a year and a half from now. Yeah.
And so let me just I know you've written 3 books, and you have your own podcast.
Well, it just started that.
I know, but I want to give people a chance to learn more about you and to have more contact with you or connection with you if they can. Because I think you're an incredibly compelling person. You've got an incredible story. Going back to your, being raised in Detroit, and the story you told about, there was your mom's boyfriend at the front door and you at the back door. I mean, these are the things that end up making somebody.
It's better. Here you go.
Yeah. Okay.
How many guys have you interviewed who've had to crash their own father's funeral? So my father didn't want me to know when he died. But I found out. So I go down to Virginia, and his new wife's family's down there. They didn't know I existed. So I walk in, I'm a ringer for the guy I kissed the corpse, and they almost died. So there you go.
So those are great. You've got to have a chip on your shoulder to crash your own. And you're not talking about wedding crashes or funeral crashes like that. You're talking about really just, why did you want to go? Did you just want to go? Tell me why. What was the motivation?
He left when I was about 7, and I didn't see him until after I'd been on Good Morning America, of all things, on a case. His wife tracked me down, and I went to meet him, and he lied to me about what had happened. And I was disappointed, and we just never could connect realistically. But he and his wife were in touch with my kids, who are all adults now. And when I heard he died, it was just there was no question. I don't know why. It was just, I had to be there. I wanted, he wasn't there when I needed him.
Was it for closure?
I don't know. I just wanted to be there. I just wanted to be there. The irony was he was very involved in creating group homes for troubled teenagers in Virginia and been honored by the governor of Virginia. And I remember thinking, man, I was one of those troubled kids. I could have used him. I wish he was there when I needed him. I guess I just wanted to say goodbye.
I get it. I get it. I get it. So again, the reason why I want to give people an opportunity to find more out about you is because you are such a compelling person. And maybe you're like me and you're not great at receiving compliments, and that's, part of your makeup. It's certainly, I'm a lot more apt to compliment myself than I am to receive one well from somebody else. So hopefully you'll let me pay you this compliment. You are an incredible lawyer. You're an incredible person. You've done great things for the people you've represented. And I want people to have a chance to get to know you more outside of this podcast if they want to. So you have a law firm. What's the name of your law firm?
Pattis & Smith. We're in New Haven, Connecticut. And
you have a website. What's the website name?
It's a great question. I think normpattis.com or something like that. And I have a blog page, Norm Pattis blog. And I started a podcast about a month ago called Law and Legitimacy.
All right. So I think your web name, you have normpattis.com, right?
Right.
That's your law firm. That's your law firm website. Is that right?
Yes.
And then you have Norm Pattis blog, what's really pattisblog.com. So pattisblog.com. And that's where you talk about just a whole variety of criminal justice, trials, politics, things like that, right?
I bitch and moan about the world, right?
Okay. And then tell us again, you have your own podcast. And what is the name of your podcast called? Law and Legitimacy?
Yeah, it's law and legitimacy. My view is that the country's at a turning point, and we need to learn how to talk about common norms and common values, or we're going nowhere good in a hurry. So the point of the podcast is to look at public events, public issues, and try to find common ground on the dimensions that divide us.
And where can people find your podcast if they want to listen to it?
Apparently, I've got a fellow who's helping me. So we're on all the things, Spotify, this, that, and the other thing. So if you type in law and legitimacy, I think you'll find it.
Okay. All right. So Norm Pattis, you got normpattis.com, you've got pattisblog.com, and you've got Law and Legitimacy podcast. Norm has 3 books that are all available on Amazon. I think are they an Audible version too?
I have no idea. I don't know.
And if there's any big case, look, to those of you who don't know, if there's any big case in Connecticut, you can be rest assured, as you already heard Norm say, if he doesn't have it, he probably either turned it down or they're getting ready to hire him. One of those, but it's probably one of those 3. He either turned it down, he's representing the people, or they're talking to him about taking over the case because he's the guy. So Norm, I really appreciate it. I just want to tell you one anecdote and then I'll let you go. I know you came to Michigan to watch Jerry Spence in one of his last trials,
with Jeff Feiger. Yeah.
Jeffrey. And there was and I know you did some commentary on it, or at least you wrote on your blog about going to watch Jerry again and watch him in action. And there's a phrase that you used earlier in our discussion, and you used it in your blog at that time. And you had talked about watching Jerry cross-examine this detective or an officer in the case. And you said it was good to see him in action. It was death by 1,000 cuts. And there was definitely, you said, blood on the courtroom floor. And I never forgot that those phrases tied together, that some cross-examinations are knockouts, but some are just slow and methodical and are just death by 1,000 cuts. And by the time the witness stands up, there's just, there's proverbial blood spilled everywhere. And that was the picture you painted to me of the way that Jerry had conducted a cross-examination in that case. And it stuck with me all these years later. So it worked with me and it resonated with me. So Norm, I really appreciate the fact that I got to know you. I know that you're
well, let's try something together sometime.
I would think that would be awesome. That would be great. We got to get you. I know you haven't tried any cases here in Michigan. We got to get you here to Michigan, right?
Homecoming. I'm ready.
We got to get you to Michigan because this is like before. This would all be full circle. The kid from Detroit makes big, becomes a big time lawyer, and comes back to his hometown to try a case. So I think that'd be awesome. Anyway, Norm Pattis, I've told everybody how to reach you. This is Neil Rockine. This is Killer Cross Examination. If you like this podcast, which I certainly hope you do, subscribe to YouTube, subscribe to on Apple, Spotify, Google Podcasts, click like, give us some feedback. And like I said, we've told you how to reach Norm. He's a compelling guy, and you'll see and hear big things from him in the future. Norm Pattis, I appreciate you appearing on the podcast, and I wish you well, man.
Thank you. Thank you for having me. Thanks, everyone.
You bet.
Killer, killer.